Amendment 4.
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
In some countries, even today, police officers may search a person's home or office for evidence of wrongdoing, seize his property, and arrest him whenever they see fit. In the United States, on the other hand, the Fourth Amendment protects the individual and his property from unreasonable search and seizure by officers of the law. In most instances, the police officer must first go to a magistrate and convince him that there is probable cause, good reason, to believe that the individual involved has committed a crime, or that he has in his possession the fruits of the crime, or other evidence that he committed it. The magistrate, if convinced, then gives the police officer a court order called a warrant, permitting the police officer to search a precise place and seize the things described in the warrant. In searching for evidence, police are required to operate under strict legal procedures, as a ruling by Mr. Justice Felix Frankfurter points out.
The knock at the door, whether by day or night, as a prelude to a search without authority of law, but solely on the authority of the police, is inconsistent with the conception of human rights enshrined in the history and the basic constitutional documents of English-speaking peoples.
Although the sanctity of one's privacy against illegal intrusion is one of the most important basic rights in our Constitution, experience has shown that such intrusions occasionally occur at the hands of overzealous police officers. Where this is the case, the court has ruled that neither federal nor state governments may use for prosecution such evidence obtained illegally. In words written by Mr. Justice Tom C. Clark, the court said,
"We hold that all evidence obtained by searches and seizures in violation of the Constitution is by that same authority inadmissible in a state court. Were it otherwise, then the assurance against unreasonable searches and seizures would be a form of words, valueless and undeserving of mention in a perpetual charter of inestimable human liberties."
Amendment 6.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation.
To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
The Sixth Amendment enumerates specific rights guaranteed to the individual who is prosecuted in federal court. It requires that the accused be brought to trial without unnecessary delay, and guarantees that his trial will not be a secret one behind closed doors. The right of trial by jury was considered so important that it has been stated twice in our Constitution, in Article 3 and here in Amendment 6. In federal prosecutions, a jury of 12 and a unanimous verdict are required. But the Supreme Court has held that in state prosecutions, lack of a 12-man jury trial is not necessarily contrary to the standard of a fair trial, and therefore not contrary to the Due Process Clause of Amendment 14. However, the Constitution requires that when a jury is used, either in a state or federal trial, it must be impartial, and that persons cannot be excluded from jury service merely because of their racial, economic, religious, or other group affiliation. The remaining clauses of Amendment 6 relate to the fact that federal trials must not only be held in the state wherein the crime was committed, as required by Article 3, but also in the district wherein the crime was alleged to have taken place. Following this, Amendment 6 stipulates that the accused must be given notice in what respects it is claimed he has broken the law, in order that he may have an opportunity to prepare his defense. Generally, the accused is entitled to have all witnesses against him present their evidence orally in court, and, subject to certain exceptions, hearsay evidence cannot be used in federal criminal trials. Moreover, the accused is entitled to the aid of the court in having compulsory process issued, usually a subpoena, which will order into court those persons whose testimony he desires at the trial. Finally, the accused in any federal criminal case is entitled to a lawyer and must be provided with one by the court if he cannot afford the cost. A defendant may, however, waive the right of counsel, provided he fully understands what he is doing. Although the right of counsel granted by the Sixth Amendment applies only to federal trials, its principles are so important to a fair trial that they are often held applicable to the states as a rule of due process. Mr. Justice George Sutherland explained the reasons for the rule thus.
The right to be heard would be in many cases of little avail if it did not comprehend the right to be heard by counsel. Without it, though the layman be not guilty, he faces the danger of conviction because he does not know how to establish his innocence.
Amendment 7.